Judge, I can tell you exactly what you may be talking about.
Hold on 1 second. I don't. Joanne, you gave me this.
Thank you, Judge.
All right, so Mr. Vila.
Man, Judge, you know these seats get hard.
I'm sorry. I'm so sorry. It was a busy morning. All right, so this is in the matter of the people of the state of Michigan versus Israel Vila. We have two files, 25-22210FH and 25-22368FH. I have, let me see, Mr. Malaro appearing today on both of these files for pre-trial. So, and Isaac Sneed appearing on behalf of the people. I do show Ms. Underwood had one file, which is, so do you have both of the files now, Mr. Malaro?
Yes, Your Honor, all files of Mr. Vila belong to me.
Okay, all right. So Mr. Malaro, how would you like to proceed today?
Your Honor, I'd ask to adjourn these matters. I had a conversation with Miss Arnold yesterday. She's the prosecutor assigned to the case. She's actually talking to me about the matter. We're making progress towards resolution. I think probably what we'll do next is between now and our next court date, set a bench conference with the court and see if we can reach a resolution. So that's the basis for my request.
All right. My next available pretrial is January 14 at 8:30 in the morning. Can you do the step in order to adjourn? And Mr. Sneed, can you sign your name with permission?
Hey, Judge, can I ask you?
Hold on, Mr. Vila. Hold on 1 minute. Just give me a minute. Can you do that, Mr. Malaro?
Yeah, I can do the step in orders, Judge. Anything for you.
Right, so Mr. Vila, Mr. Malaro is going to meet with the prosecutor and meet with you. If
listen.
a resolution is reached, no, you listen.
Okay.
Mr. Malaro will call and get you in sooner, and I will see if they'll provide cushions for you next time. But
all right, listen. I'm not worried about no court date. I don't care if the court date's pushed back a year from now. I'm content where I'm at. But I got one question about my bond, right? So I just want to make sure my bond is correct because I've been trying to post it, but they say that my bond is $75,000 cash, and the only thing that you changed was a $25,000. I'm trying to make sure it's only $2,500 that I got to pay because you only changed one bond, and the other bond got raised upstairs $50,000. It was supposed to be a PR bond, and you switched to $25,000. I'm just trying to make sure my bonds is correct because they've been saying $75,000. And I'm trying to get to a rehab while I'm to Dawn Farms while I do all this. I ain't caught no tickets in here. I've been trustee. I ain't worried about the court dates, you know.
okay, I'm just trying to. So I'm looking. I'm looking at. I don't post it.
Judge, in the ROA, I'm showing on the one ending in 210 is 25,000 and the one ending in 368 is 50,000.
Okay, so it's 25,000 in file number 25-22210, and she's saying it's 50,000 cash surety in file number 25-22368FH.
Right. But now listen, now Angela, when that was the one that was downstairs, and that they had gave me a PR bond on that. I bonded out on the one that you changed, and then they ended up giving my money back because you changed the other bond. So my bond was never changed on the 50,000 because that one was able to go to rehab on that one. You only changed the 25,000. So I'm not understanding why it's still not reading. I could go to rehab on the 2522368 case because y'all was only saying I had a bond out on the case I was originally upstairs for, which is 25,000. And I bonded out for the $10,000, and they ended up giving me my money back. Thankfully.
Today, Sam. I've got an Angelo here for you. He says that you're expecting him.
Hold on, I don't know who was talking. Let me see. I'm Becky Adams. The $50,000 bond, was that set up here or down? Okay, hold on.
That was set downstairs.
Hold on, we're looking. So the $50,000 bond was set downstairs.
Right.
Mr. Malaro and Mr. Sneed.
I got paperwork right here.
Did you address my book?
No, let's see. That's what I found out too.
All right, so, but we did on this one.
Right, that one's 25,000.
All right, from 50. Okay, so Mr. Sneed, it looks like we addressed bond in file number 25-22210FH, which was bound up on a different day, obviously, than the other file. So I did set a $25,000 bond on 25-22210FH when it came upstairs. On file number 25-22368FH, his bond is 50,000 cash surety, and it was obviously bound up in circuit court on a different day, and it looks like bond on that file has not been altered at all. It came up, well, actually yeah. So I think what Mr. Vila is asking is for bond to be reduced from 50 to 25 like it was on the other file. Does that summarize what you said, Mr. Vila?
No, let me try to clear. Let me try. If it could get reduced, I'm cool with it. But what I'm saying is, when I came back in here on these other cases, they said $50,000 you could go to rehab. But I also had the case with you upstairs, and that bond was $10,000. So I made the $10,000 bond for $1,100. The day that I was supposed to leave to a rehab, y'all called me in court. Y'all raised my bond to $25,000 on that case, and y'all said you was like, y'all gotta pay. You gotta pay the $2,500, which is 10% of the $25,000. In the process, since that court date, I've been trying to do it, but they said since the other case came upstairs, it's not showing that 50,000 was PR bond, can't go to rehab too. I'm trying to get to a rehab. I'm trying to get to a long-term treatment program.
Are you saying, hold on, are you saying district court gave you a 50,000 PR bond?
A $50,000 cash and surety bond, but able to go to rehab when the bed is available. And the only thing that was holding me up was the 25,000 cash with you. And I paid that. I mean, I paid the $10,000 for 1,000, and then y'all upped it to 25,000. Luckily, the bondsman gave my money back, and in the process, I've been trying to bond out, but it says it's not reading the PR bond upstairs with you. But I got the paperwork right here. Basically, I'm just trying to get it fixed, man, so I could try to at least get to a program where I continue to do my time. I'm not worried about the court date.
All right, so there was, it looks like Judge Shaler signed an order on June 3rd of 2025, allowing Mr. Vila to be released to the Salvation Army Harbor Light program. And then, yeah, okay. Mr. Malaro, perhaps you could shed some light.
Well, Judge, as I understood it, there was the district court case. I wasn't involved in it at the beginning, but there was a provision to be released to some rehab, but I think there was and again, I wasn't present for it, an emergency hearing as to his bond. And so one of the bonds, I think, was 25,000 cash or surety, but the other one, as I understood it, did allow for him to be released. And I think that's what Mr. Vilas wants clarified. I mean, obviously, if the court reduces or modifies the bond downward, he's not going to complain about it.
Angela, one more thing.
Mr. Vila, stop talking over people. We've gone through this before. Let Mr. Malaro finish. I know.
The one case that came up from district court, I think Mr. Vila is just seeking clarification that allows him to go to a rehab facility. I think that's his position.
So I will say on file number 25-22210 FH, your bond is 25,000 cash to surety. So if you post 2,500, you get out. On
Okay.
file number 25-22368 FH, and Mr. Sneed, obviously you can weigh in on this. There is an order from Judge Shadler stating that he can be released to Harbor Light on her file, on that file. So I don't think that order has been set aside, Mr. Sneed. So does that order still stand from district court?
Your Honor, I would suspect that when file ending 68FH was bound over to circuit court, that this court's bond conditions take precedent to whatever was previously ordered in district court. Also, with respect to the file ending 10FH, our file indicates that this bond modification to allow the defendant to go to rehab was tabled until there was a discussion with you. That was back in April 23rd. It was then revisited again on May 6th, where the request for bond modification was denied. Then on June 4th, you had continued the bond and set it at 25,000 cash or surety with no conditional release to rehab. Now here we are in November arguing the same thing that's been going on for 7 months. I believe there's a minimum guideline recommendation of 51 months here. So it doesn't stand to reason that Harbor Light is on the table.
It's not Harbor Light.
Or Dawn Farms.
Mr. Malaro?
Well, if someone needs, to treat their addiction, I mean, it's kind of difficult. Mr. Vila is not a person who's prone to running from the police. He doesn't go anywhere. Even if he does, he just stays home. I just think denying him an opportunity to get himself clean. I think, and although Mr. Sneed is correct that there's a guideline determined by the state, but that doesn't mean it's final. And there was some, I think, and I don't want to speak for Miss Arnold, but I thought we had some productive discussion towards resolution yesterday, although to be fair, she still was under a position of some form of MDOC sentence, but it was, I think, a little softened from our conversation. So I don't want to mislead the court since Miss Arnold's not here, but there was some softening of her position from my perspective. And that's the basis for the bench conference.
I think I lost Darren Coast. So, Miss Holly, are you still with us?
Judge, if I recall, Mr. Coast did an assessment, and I think it was not a positive one from our position.
No, I thought Mr. Coast was still with us. So if I remember correctly, so originally the plea offer was that you were going to serve 51 months with Michigan Department of Corrections, Mr. Vila. It sounds like Mr. Malaro is working on and maybe successfully getting that reduced. But because, Mr. Vila, you are looking at a prison term, I'm going to leave the bond as it is.
What about a tether?
Because you have a history of absconding, and if I remember, let me get Mr. Coast. You've left a couple facilities, so hold on. Mr. Coast, I am on the record on Mr. Israel Vila's file.
Yes, Judge.
And I know you did an assessment, which I think he maxed out as a high risk for release.
Okay, yeah.
But I also, if I remember correctly, did we arrange for treatment programs for him before?
I would have to look at my notes. Hold on one second here.
Because I remember him leaving programs.
Never left a program. Never.
Okay, hold on, there's something.
Judge, I can tell you exactly what you may be talking about.
Hold on 1 second.
I do have a note back in May, pled guilty to possession of intent to deliver, not to be released from jail to attend treatment. Yeah, I don't see where he was granted that opportunity.
Okay. All right. Okay, thank you. And Miss Holly, thank you. And Miss Holly, are you able to read any notes on his prior compliance? Because I want to say what.
I'm looking now. On 2/22/24, his probation was revoked and he did a year jail. That's the last thing. Looks like he was on with Teskey. Failed to appear for VOP sentencing on 3/3/23. Yeah, there was an absconding.
All right.
Harbor Light, he didn't report.
Yeah, I knew there was
Yeah.
something. So Mr. Vila, these opportunities have been presented before and you weren't in compliance. And in this situation, you are looking at a prison term. So
I'm not taking no prison. I'm not taking no prison plea. I'm going to trial. I'm not
Okay,
taking.
it's not up to me, Mr. Vila.
I don't care about no 50 months. I don't care about no time.
I am gonna leave your bond as it is. So we're all set. We'll see you back on January 14.
Hey,
at
do me a
8:30
favor
in
and
the morning.
set the next court date to 2028. What that? Can we do that?
Okay, so